Have you ever posted a really strong opinion online? Maybe you written a critical review or published something you felt strongly about. If you have, there's probably a word that's crossed your mind, maybe with a little bit of anxiety, and that word is defamation. So what does it actually mean here in the US? What really happens? Let's get into it. Okay, let's just cut right to the chase. This is the big fear, isn't it? You say something, someone gets angry, and the next thing you know, you're picturing flashing lights and police at your door. Can you actually be arrested for it? And there it is. The short answer is no. In the United States, getting arrested for defamation is practically unheard of. Now, that might seem surprising, but the reason why gets to the very core of how the American legal system thinks about free speech. To really get why you won't end up in jail, we have to understand this one fundamental difference. Is saying something that harms someone's reputation a crime against the government, or is it a private dispute between two people? This breaks it down perfectly. See, in a criminal case, it's the government, the state, that comes after you, and the punishment, it can be jail time. But in a civil case, it's just another person called a plaintiff who sues you. And they're not looking to put you behind bars, they're looking for money, what the law calls financial damages. So where does defamation fit into all this? Well, defamation is what lawyers call a tort. It's a fancy word, but all it means is a civil wrong, something one person does that harms another. It's not a crime, and because it's a tort, it gets handled in civil court. This is the #1 reason defamation leads to lawsuits for money, not criminal charges. Now, this whole system isn't some random legal accident. It's deeply connected to the First Amendment's protection of free speech, and it was all solidified by one single incredibly important Supreme Court case. This is the one. If you remember one case from all of this, make it New York Times versus Sullivan. Back in 1964, this decision totally revolutionized the rules for journalists, authors, and really anyone talking about public officials and public figures. It basically built a fortress around free speech. So what the court did was create this new, incredibly high bar called actual malice. Now listen, this does not mean what you think it means. It's not about being mean or having ill will. In the legal world, it has a very specific definition. It means you either knew what you were saying was a lie, or you acted with a reckless disregard for whether it was true or not. The exact wording from the court is so important here. Reckless disregard isn't just about being a sloppy reporter or making a mistake. It means you literally had serious doubts about whether your story was true, but you published it anyway. As you can imagine, that is an incredibly difficult thing for a plaintiff to prove. Okay, so that's the super high standard for public figures, but what about defamation in general? Well, for any lawsuit to succeed, the person suing has to prove 4 specific things. You can think of it like a 4-part test they absolutely have to pass. So here's the test. First, they have to prove there was a false statement of fact, not just someone's opinion. Second, the statement had to be clearly about them. Third, it had to be published, which just means it was communicated to at least one other person. And fourth, it had to actually cause real, tangible harm to their reputation. And here's the kicker. This is an all-or-nothing deal. The plaintiff has to prove all 4 of those points. If they can't prove even one of them, just one, their entire case usually falls apart right then and there. So we've looked at what the other side has to do. Now let's flip the script. If you're the one being accused of defamation, what's protecting you? What's your legal shield in this fight? You've actually got a number of powerful defenses. You can argue that what you said was true, or that it was just your opinion. If the plaintiff is a public figure, you can point out they didn't prove actual malice. You can also argue there was no real damage to their reputation. And finally, there's something called privilege, which protects statements made in official settings, like in a courtroom. These aren't loopholes, they're fundamental legal protections. But out of all those defenses, one of them stands head and shoulders above all the others. It's the ironclad, #1, absolute best defense you can have. And it really is that simple. It doesn't matter how mean a statement is or how much it hurts someone's feelings or their reputation. If what you said is substantially true, it cannot be defamation. Period. End of story. So let's bring this all home. We started off by making it clear that you're not going to be arrested for defamation. But, and this is a big but, that doesn't mean there are no consequences. The real risk here isn't jail time. It's your bank account. Getting sued for defamation, even if you eventually win the case, can be an incredibly long, stressful, and expensive process. And if you lose, the damages can be huge. So while jail is off the table, the stakes are still very, very high. And that kind of leaves us with this big, lingering question. The United States gives some of the most powerful protections for free speech anywhere in the world, which makes it hard to sue for defamation. But at the same time, we all know that lies can cause real, lasting harm. The law we've just been talking about is society's attempt to find a balance. The question for all of us is, do you think we've drawn that line in the right place?